Okay, the operation of the Supreme Court in the doctrine of precedence. Okay, from what we've seen, I think the 1999 Constitution establishes the Supreme Court, talks about its composition, talks about its jurisdiction, whether it's the original jurisdiction or the appellate jurisdiction. Now, we are not going to go into detail of all of that. We're just going to look at two issues that have to deal with the Supreme Court. Well, first of all, you know that being at the top of the court, that the decision of the Supreme Court is binding on all the courts beneath them. So its decision binds the Court of Appeal, binds the Federal High Court, binds the High Court, and all the way down. Sharia Court of Appeal and the rest of them don't apply adjectival law, but it's been suggested by Obilade and the rest of them that since their appeals still go to the Supreme Court, they should also be bound by the Supreme Court. Now, the first issue we'll look at is the issue of whether the Supreme Court binds itself or whether it can depart from its own decisions. Its decisions. It binds all the court beneath it, but does it bind itself? That's one very important question. And then, in answer to this, the Nigerian courts have also adopted the it was a practice direction. It's a practice direction that was given by Lord Gardner in England for the House of Lords. Practice direction by Lord Gardner. The practice direction was to the effect that though the highest court in the land will have to respect the doctrine of judicial precedent, but it cannot over adhere strictly to the binding precedents, because if it does so, it might hinder the development of the law, so that the apex court in the land should be free to depart from its own precedents anytime the proper conditions exist. And so in Nigeria, we have also adopted that, and in the case of Bronick Motors and Wema Bank, the Supreme Court established that it will depart from its own previous decisions if there is a breach of justice. If there is a breach of justice, if there's a question of public policy question, or if within the judgment will amount to a perpetration of injustice. Now, those were the three original conditions that were set out, but the court has kept on expanding the conditions that will exist, and it will change the decision. In a lot of decisions, you had a case of Abdul Karim and Inca Motors, and then recently we have the case of Chief Adedayo and the PEP. So some of the other conditions that the court have held that will lead to the court's overruling its decisions include if there is an error in the judgment, if the decision was given per incuriam, if the decision is a vehicle of injustice, if the decision will fetter judicial discretion, if the decision will hinder legal development. Now, these are a lot of the other grounds that have been set apart from the first three that have been put there. So basically, the Supreme Court has a right to depart from its own decisions if these particular conditions are met, and it has done so many times. But we'll just look at the case of Adisa and Onyewola, decided in 2000, which overruled the Supreme Court decision in Oyediro and Ebotola, which was decided in 1997. Now, this case had to do with whether the High Court has jurisdiction over lands that are not situated in an urban area. Based on the Land Use Act, initially the court had held that the High Court does not have jurisdiction, but then in Onyewola the court overrule itself. That the High Court has unlimited jurisdiction, so you should be able to also have jurisdiction over lands that are not situated in the urban area. So that settles that, and there are a lot of other cases that the court also departed from its own decision. Now the second issue that concerns us is what will the lower court faced with the conflicting decisions of the Supreme Court do. And before 2010, there were two opinions about what the court could do. And the first opinion, for example, if we look at Ashemo, and Abraham, or Adekoke Motors, and Adesanya, the court had held, and in a lot of other cases after that the court can pick and choose. The court can pick or choose which of the two decisions of the confidential they can take. And the other view before 2010 also could be found in UTC and Pamote, Suf and Ebe, etc., where the court had held that the right decision should be that the court should choose the later decision. Now, this unsteady state of affairs continued until 2010 in the case of Osakwe and Federal College of Education, Asaba. In that case, the court stated emphatically that when there are two conflicting decisions of the Supreme Court, that the lower court is bound to follow the later decision. And even though it could look as if, well, it was still the same thing that had been going on all the while, but since 2010, the court decisions have been consistent. In fact, the judges have started saying it categorically that it's already a well-established law or a settled law that if there are two confidential of the Supreme Court, the lower court is bound to follow the later decision. But in Opene and National Judicial Council, which is the 2011 decision of the Supreme Court now explained why the right law is that they should follow the later decision. In that decision, the Supreme Court explained that since the Supreme Court has the power to overrule itself, that if the Supreme Court makes a later decision that is inconsistent with an earlier decision, that later decision will be an implied overruling or repeal of the initial decision, and as such the initial decision will no longer be good law. And so based on that, that's anytime there is a conflict decision of the Supreme Court, that the lower court should be careful to follow the later decision. So that's what has been titled the settled decision from 2010 based on Osakwe, and later decisions say you must use the later decision. So based on this, the issues that we've mapped out is that the Supreme Court binds all the courts beneath it. It doesn't bind itself so much, but it respects precedents. But whenever there is the conditions are met, can depart from its own decisions. And then if there are complete decisions of the Supreme Court, there is a need to adopt the later decision. So we'll now look at how the Court of Appeal also operates its own doctrine of judicial precedent.